Morning. And let folks come on in. Morning. Oh, hey, why am I so small? Why am I small? Don't want to be small. I'm going to make myself bigger. And I'm going to hide that. Alright, morning folks. Sorry about the delays this morning. So I have this cat, right? And he's the one cat in the house that gets wet food, because normally I don't feed wet food, but he was losing weight on the dry, so. He normally wakes me up at 6:30 every single morning, so I thought, do I really need to set an alarm? He does it every morning, but yeah, I'll set an alarm anyway. Set an alarm on my cell phone for 7 a.m. just in case. Well, the damn cat didn't wake me up. It's right over there, damn cat. And for whatever reason, my cell phone alarm didn't go off either, so I woke up at about 8:15, and I haven't showered since Sunday. Well, I have now, but I hadn't showered since Sunday, and I just didn't want to show up on live stream looking like I hadn't showered since Sunday. So here I am. I'm here. We're running a little behind. If you got to skip out and go to another class, that's fine. Obviously, you can pick up on the recordings later, and I do also welcome questions through Canvas message as well. I am here. I'm online all the time. And I think it's about time for us to get started. Let me grab my judicial chapter notes real quick here. We're going to talk today about the judiciary. And I want to first mention that, remember back during chapter 13 it was, when I said that you can kind of take a lot of what we talk about in terms of the federal government and apply it straight to the state governments? That is true in a lot of cases in Nevada. It's true in a lot of cases in a lot of states, but often states have exceptions. For example, 49 of our 50 states have bicameral legislatures, 2 houses in their state legislature. So, you can learn about that bicameralism by looking at the federal government, and it applies to 49 states. But Nebraska's a little different. Excuse me. And, but Nebraska's a little different. They only have 1 house in their legislature. It's also the only nonpartisan state legislature in the country. So some states are a little different, is what I'm saying. When we get to the part about judicial federalism in this chapter and how it talks about the state judiciaries, ignore it. There's going to be some charts and there's going to be some stuff on the slides. State courts in Nevada work very differently than federal courts, and we're going to talk about it not very differently, but the structure of the whole system is very different. This is how your textbook authors think that it's organized, local trial, state appeals, highest state court of appeals, but I'm pretty sure that I have somewhere in here diagram of how it's actually organized. That's just the right half of that previous diagram. So you can see it's a little different, and we'll talk about that in more detail when we get to the Nevada chapter. But I'm just giving you that heads up that the way that the courts work at the federal level is not necessarily the way the courts work at the state level, especially in our beloved Silver State. So, we're going to talk about the courts. We're also going to talk about the law and lawyers and, courts as an institution outside of the formal, institutional setup of the court system. Then we will talk about the court system. We'll talk about the role that the courts play in politics. So, I told a joke one time. So, what do you call it when you cross a lawyer and a politician? Your Honor, right? Lawyers and politicians both have very, very low levels of prestige in our society, but for some reason, I'm not stuttering, and my video is actually running today, so that's pretty great. But for some reason, again, when a lawyer gets elected and becomes a politician, for some reason we respect them a lot more. So we'll talk about the court's role in American politics and how judges definitely are politicians. Right? We'll talk about the inner workings of the Supreme Court, including their recreational opportunities. We'll talk about how judges decide cases. Spoiler alert, it's mostly partisanship. We'll talk about 19 cases you should know. They're all in your textbook, but I'm going to go over them all anyway, with the help of my trusty friend Wikipedia. And we'll talk about various proposals for reforming the court system, because there are many issues with our justice system, particularly our criminal justice system, but also with civil law in the United States as well. It was not the intent of our founding fathers to set up a system where the party that won was the party with the better attorney or the deeper pockets, but that is very much how the system works today. And part of that is compounded by the fact that we are a nation of litigation. Americans file an enormous number of lawsuits. I think it was about 150 million legal actions pass through American courts every year. 150 million legal actions. There's only 330 million Americans. So, look to your left, look to your right. One of those people sued somebody last year. It actually doesn't work like that. Most lawsuits are filed by corporations against other corporations, and so it's not like every individual is getting in court every year, but we still have an enormous amount of litigation in our society compared to others. And somewhere in here, somewhere in here, sorry, I think I might need to look up the art slides, because for some reason they give me extra art, but they don't put it in the slides. So let's look at the chapter 16 art slides. Slideshow. There it is. So I call this the worst chart in the world. It has been in your textbook since 2014, apparently. I've seen it there since the second edition. We're now in the fourth. I've written to them to complain about this chart. I hate this chart. But it makes a point. In fact, it makes the exact opposite point that it tries to make. Okay, so if you just look at this chart, actually, if you look at the chart on the slide, it's captioned number of lawyers per capita. And so you'd look at this chart and you think, oh, the U.S. doesn't have that many lawyers, right? Brazil's got some, India's got a bunch, good goddamn Japan is lawyered up, right? That's not what this chart is saying. And you wouldn't even know that if you didn't look this chart up in your textbook, and I forget what page it's on, but it's in chapter 16. Because if you look in the fine print of the caption in the textbook on this chart, what it says is, one lawyer per X number of people. And so the point that you get out of this chart, if you just look at it and you just look at the headline, is Japan's really lawyered up, the United States doesn't have many lawyers at all. Which is the exact opposite of the actual point. In reality, the United States has one lawyer for every 275 people, whereas just in Canada, America's halved. They have almost half that, right? One lawyer for every 450 people. And in Japan, they only have one attorney for every 5,700 people. So there's very, very few attorneys in Japan at all. How do most of these countries solve their problems? Well, most other democracies, other than ours, use mediation. They have a branch of their civil government dedicated to negotiating a settlement between third parties, or in some countries it's it's a for-profit institution. In some countries it's some sort of civil society group, some sort of community board. In some countries it's religious authorities. But in most countries there's some process of mediation where a third party helps the two parties at issue negotiate a settlement in the case without going to court. Court is often seen in those countries as a last resort. But of course in the United States, litigating is often seen as a first resort. I mean, how often have we at least threatened it? I'm going to sue the pants off you, right? Sometimes it works. Threats of lawsuits can be powerful. And so we are a uniquely litigious nation. We have an enormous amount of laws, or an enormous amount of lawyers, an enormous amount of courts, and actually I shouldn't say an enormous amount, but an enormous amount of lawyers, an enormous amount of legal actions that go through our courts, which are, by the way, like every branch of our government, underfunded and operating well above capacity. So historically, Americans have placed a lot of trust and prestige in courts. We even have, these ideas of courts as these places for righteous judicial combat, where the little guy can triumph over the great evil, where truth and righteousness will prevail, right? You can see that in our media. Where's my media? Famous classic novel, and there was a 1962 film adaptation that was apparently quite good. I've never seen it. To Kill a Mockingbird, right? This is a book about racial inequality and in the Deep South in the 1930s, and it's about the main character's father is defending a black man falsely accused of rape, right? And the book paints the court as a place where at least this person could try and find some justice, right? Not necessarily, or this is a, or I remember a big movie from my childhood. There's the actual woman, but 2000 was a big deal. Erin Brockovich, right? A biopic about a paralegal in Los Angeles who found out about PG&E. They are evil. PG&E poisoning the water supply of the small town in Hinckley, California. Which, by the way, if you drive from Las Vegas to Los Angeles, you pass Hinckley every single time. You can see it off on the distance to the right, just after you go past Barstow. So it's not too far away. But again, this is a film that paints the courts as a place where a bunch of scrappy rural plaintiffs and their equally scrappy attorney, if they just push hard enough and fight hard enough, well, they can get justice in the legal system, right? And that actually was a really big deal when PG&E got a judgment against them. PG&E, by the way, is now guilty of like 400 felony counts of attempted murder in California because of some exploding gas piping in San Bruno and a couple of wildfires now. So that's a fun story. But we have a number of examples all over our media where courts and lawyers are seen as kind of, crusaders for righteousness. Even if that's not necessarily the public image or in any way an accurate image at all. But this idea has roots in our American culture. Today, though, we are seeing that public approval for the courts has been kind of dropping over the years. This is Americans' confidence in the Supreme Court. You can see it was actually reasonably high, but even in the 1970s, it was 45%. This is the percent of Americans who said they have a great deal or quite a lot of confidence in the Supreme Court. You can see kind of a gradual decline, where, the Supreme Court's down in the 30s now. These aren't Congress numbers. Congress is, sometimes posts single-digit approval numbers. I think they were up to 19 last I checked. Congress, terrible approval numbers. Even the president would probably be pretty happy to be consistently in the 40s. But Supreme Court historically enjoyed a lot more prestige. However, we've seen controversial cases where the Supreme Court has been acting less and less like an impartial arbiter of the law, and more like, a mechanism for enshrining Republican power forever. And this is not lost on the American people. Starting with cases like 2000's Bush v. Gore, where the court was basically seen as handing the election to George Bush because they had a Republican majority, to more recent cases like Citizens United, which we talked about in the Campaigns on Elections chapter, or McCutcheon from the same chapter, or from way back from civil rights, Shelby County, Alabama v. Holder, the case that gutted the Voting Rights Act, right? Even more recently, we've seen decisions that are just seen as blatantly partisan and threatening the legitimacy of the Supreme Court. So things like, where in South Dakota, they said that the Supreme Court was okay with disenfranchising, every person who lived somewhere where they didn't get street mail delivery, right? If you didn't have your street address on your ID, you wouldn't be allowed to vote, and most Native Americans didn't. So that's obviously racially discriminatory voting law. The Supreme Court said it was okay, right? The Supreme Court allowed the allowed the Ohio election to enforce its pre-existing deadlines that existed before the coronavirus. In Wisconsin as well, people were requesting ballots and weren't getting them by the deadline because everybody was requesting absentee ballots because we're all staying at home, right? So more and more Supreme Court decisions are looking just like blatant attempts for partisan advantage, and that has started to erode Americans' trust in the courts, especially after the freaking Gorsuch thing, where Mitch McConnell stole a Supreme Court seat from President Obama. He stole a Supreme Court seat, folks. I'm sorry, I'm not over that. Like, we are so far outside of the territory of normal politics that the Senate stole a Supreme Court seat from a Democratic president for no other reason than that he was a Democratic president. Right? Controversies like that have been ticking that Supreme Court approval rating further and further down. So, organization of the courts. As with our legislatures and our executives, we have a federal judicial branch. And by that I mean we have a federal system within the judicial branch. We have judicial federalism. We have federal courts for the U.S. government, and then we have 50 different state courts. We also actually have territorial courts too, but those are technically also part of the U.S. government. Let's not get into that. Point is, we have different layers of court systems. And at both layers of court systems, we broadly see the same pattern, where lower courts conduct trials, appellate courts hear appeals, and a Supreme Court, both at the national and the state level, renders a final verdict. Though, as we're going to see, in some cases can be appealed from the state Supreme Court to the national Supreme Court in cases where the U.S. Constitution or some sort of federal law is at issue. So, state and local courts are the same way. They have trial courts, they have appellate courts, they have a Supreme Court. In Nevada, cases do not flow through them in the same way that they do in the federal system. Cases actually go to the Supreme Court first, and then they get kicked down to the appellate. It's strange. There's also some, sub-trial courts that are like the justice courts. So if you ever got a traffic ticket, you're familiar with the justice courts. Just had to pay one of those off. So all of that exists at the state level as well, although, as I said, it works a little differently, so you can just ignore this right-hand side of this diagram. It works a little differently in Nevada. But at the federal level, judges are appointed by the president and confirmed by the Senate, which is, by the way, the one thing that the Trump administration and the Republican Senate are doing a whole lot of. Not a whole lot of policy coming out of either, but Trump is appointing a lot of judges, and in the federal system, they get appointed for life. So, we're going to be dealing with cases like Citizens United and Shelby County and this Wisconsin primary thing, I can't remember the name of it, for a very long time. Because these judges are going to be on the bench for life. The only way to get rid of them is by impeachment, and y'all have seen how well that works, right? It is a different story in states, though. Some states appoint their judges by, have their governor appoint judges. Some states have their judges appointed by state legislature. Most states, actually, though, including our own fair Silver State, elect their judges. The position of judge is an elected position in Las Vegas. And if you do go outside, which you should only do to get essential supplies, you are probably seeing posters along the roadside for, elect so-and-so district court judge, elect so-and-so district court judge. There are 52 of those offices on the ballot this year. 52. So you're going to see a lot of posters about elect so-and-so district court judge, because they're all running county-wide. We'll talk more about that when we get to the Nevada chapter. But so Nevada, like most states, elects judges to every level of court, from the justice courts all the way on up through the Supremes. Every level of court in Nevada is elected. So we have state courts. We'll get into more detail as to how those work when we get to the Nevada chapter. We also have the federal courts. Federal courts are the smaller part of our judicial system. We have to pay more attention to them because they are federal, but they really actually have relatively limited jurisdiction. The vast majority of legal actions are filed at the state level. Most criminal cases are state cases. Most civil cases are state cases. Federal courts only deal with crimes that violate federal laws. So, famously, if you rob a federally insured bank, that is a federal crime, and you go to federal prison, right? But issues that involve federal laws, which mostly do not cover basic, low-level, everyday criminality. There is, no federal probe or assault and battery or drunken disorderly, these are not federal crimes, they're local crimes, right? Issues that involve federal treaties. If you're found violating a treaty to which the United States is a party, you can end up in federal court for that. Cases that touch on the U.S. Constitution. So if somebody alleges that their rights are being violated, those cases can go under the U.S. Constitution or the Federal Bill of Rights. Those cases can go to the federal courts. Federal courts also handle what's known as a diversity of citizenship, where two parties are in different states. So if you're in Nevada and you sue somebody in California, you're probably going to have to do so in, the federal courts, probably either Federal District of Nevada or the Federal District of one of the 3 federal districts in California. Probably Nevada because it's closer and you don't want to be flying back and forth all the time. Make the corporate lawyers do that. They can afford it. They got expense accounts. So that's what federal courts cover. And federal courts start out at the district court level. The U.S. federal district courts, there are 94 of them. So most states, the average state has more than one. But less than 2, actually, like 1.8. Naomi, not on the keyboard. Sorry, there's a cat here. But whoops, she went the wrong way. Ow! No, you cannot come in here and start biting me while I'm teaching. So there are 94 federal district courts. Most states have more than one. But every state has at least one. So pretty sure Nevada is one of those. We only have one of them states. We have like a federal district of Nevada, but California has 3. So they got our second one. California has southern, central, and northern districts. I told you can't be on the keyboard. Ow, ow. Everybody, say bye to Naomi. Bye, Naomi. So those are the federal district courts. The district courts are the trial courts, right? So when you think of a court, you think of a courtroom, and they got the jury box, and then they're calling witnesses and all that good stuff. What you're thinking about, ma'am, don't headbutt the microphone. Could you not? What you're thinking about is a trial court, right? That's the court where they hold trials. And it's the only level of the courts, by the way, that has a jury. All of the appellate courts, there's no jury, just a judge. But so at these trial courts are set up to determine what are known as questions of fact. So their job is to figure out what happened. Who wronged who broke what law, etc. And, so juries decide on that, whether somebody is guilty or not guilty, right? At the federal level, juries do need to be unanimous. At the state level, we'll talk about that. They do need to be unanimous in the criminal arena, but not in the civil arena. As I talked about, federal district court judges are appointed by the... Ow, ow, ow! Federal district court judges are appointed by the president, subject to approval by the Senate, and once approved, they do hold that office for life. Are you back? Why are you biting me? I am going to have to shut you in the bedroom if you keep coming back. Ah! Okay. Little shit. District court judges are appointed by the president for life, subject to approval by the Senate. It used to be that was subject to a Senate filibuster, but Mitch McConnell broke that too. It was subject to a filibuster when there was a Democratic president, and then as soon as there was a Republican president, it was a simple majority. Funny how that works. And they hold that office for life. Right? They hold that office for forever. It can be removed by impeachment, but that's it. And as I've noted, impeachment not a terribly effective process historically speaking. So those are the district courts are where they hold trials. Now, so if you do rob a bank, right? You rob a bank and you get arrested and you go to court. You go through the district court process, and they have a trial, and the jury stands up and says, "Your Honor, we find the defendant guilty." But you feel like the prosecutor violated your Fourth Amendment rights because he didn't have a warrant when he searched your house or something like that. And the judge should have excluded it, but he didn't. Well, you take that appeal up to the next level. The next level is the federal circuit courts. Sometimes these are called the courts of appeal. And they're called the circuit courts, by the way, because originally the courts of appeal did not have a permanent courthouse. The judges would actually ride around on a circuit, and they'd start out from so let's take a look at, here are the judicial circuits as they exist today. And so if you were a judge of the First Circuit, you'd you'd probably spend most of your time in Boston, but you'd ride out to Western Mass one day, and you'd ride up to this is New Hampshire. You'd ride up to New Hampshire. I should know it's New Hampshire. I have a friend who lives in New Hampshire. And you ride up into Maine. You get out to Portland and Augusta and hear their appeals. And you kind of come on back down. So they would ride around on a loop, on a circuit. And that's why they're called circuit court judges. Circuit courts are the courts of appeal. So when you feel like your rights have been violated in the district courts, then you go up to the courts of appeal and you ask them to take a look at it. Appellate courts are not supposed to find new facts, right? Unless you present them new evidence, in which case they typically will order a new trial at the district courts. Appellate courts are not there to find questions of fact. They don't typically rule on who did what to who, when and where, and that sort of thing. Their function is to talk about questions of law. Was the law properly applied by the district court judge? Were you given due process of law? Were your rights respected? Did the judge interpret the law correctly when he excluded that piece of evidence or not? Right. The circuit courts are organized along these geographic circuit lines. As you can see, they are numbered, and they do not break states in half, right? So they don't cut across any federal judicial districts, and usually they don't cut across any state lines. So every state is within one and only one judicial district, with a slight exception that we will talk about in a bit. You guys are going to learn about the zone of death today. See, I throw that shit out so you keep paying attention. But anyway, so these are the various circuits. You may notice something, that the circuits on the East Coast are highly, highly concentrated. The circuits on the West Coast, not so much. This made a lot of sense when the circuits were set in the early 20th century, but the Ninth Circuit is actually now by far the most populous circuit, because it includes not only California, but also Oregon, Washington, our own fair Nevada, and Arizona, and then Idaho and Montana, but nobody lives there. But and so it includes Seattle, Portland, San Francisco, Los Angeles, Sacramento, Bakersfield, Fresno, San Diego, Phoenix, and Las Vegas. Quite a few people live in the Ninth Circuit. And I guess Alaska too, but again, nobody lives in Alaska. So the Ninth Circuit so the circuits are known for particular ideological leanings, right? The Ninth Circuit is the hippy-dippy liberal one, right? The Ninth Circuit's main courthouse, they have a lot. I'm pretty sure they have one here in Las Vegas. I know they have one here in Portland. But I know they have one in Los Angeles. Their main one is in San Francisco. The headquarters of the Ninth Circuit is in San Francisco, California. So what do you expect about a court headquartered in San Francisco? They're pretty far, judicially, as hippy-dippy as you can be and still be a federal appeals court judge, which isn't that hippy-dippy, but it's pretty progressive, right? So the Ninth Circuit is often subject of very progressive rulings. other circuits have, other reputations, right? So the Fifth Circuit, which is headquartered in Dallas, has a much more conservative leaning to it, right? And it should be noted that circuit court rulings only apply in the circuit where they are handed down, right? So they may be used as guidance in other circuits, but they're not binding on other circuits. So that can lead to a sticky situation where the law is actually different. Federal law is actually different because it's interpreted differently by two different appeals court circuits. As we'll talk about later, the Supreme Court doesn't like that situation. They try to fix it. But that currently exists today. So in the Seventh Circuit, the appeals court there has handed down a ruling that says that discrimination against LGBT people is sex discrimination and therefore illegal under the federal civil rights law. The Fifth Circuit, the conservative Texas one, has handed down a decision that actually finds the exact opposite, that discrimination against LGBT people is not in violation of federal civil rights law. So right now, if you live in Wisconsin, and you're an LGBT person, federal law protects your right to a job. But if you live in Texas and you're an LGBT person, federal law doesn't protect your right to a job, even though it's the same laws, because they're interpreted differently by different courts. Incidentally, in Nevada, we do have a state law protecting LGBT rights. Well, we have two different ones. We have one for sexual orientation and another for gender identity. We'll talk about that when we get to state laws. But the point is that different appellate circuits can find very different things. And so, it is not that far of a drive from Cairo, Illinois to the northern tip of, I think this is Mississippi and then Louisiana. So the northern tip of Mississippi. So you can drive, what is that, probably 3-4 hours? And go from a place where federal law protects LGBT people to one where it absolutely does not. I actually think the Sixth Circuit might not either, so it might be just as simple as taking the train to Gary, Indiana. No, I guess Indiana's in the 7th, so it might be just as simple as hopping the river to Kentucky. So let's talk about the zone of death. So as I mentioned, the Ninth Circuit is the hippy-dippy liberal one. 10th Circuit is, some of the more conservative western states, although, Colorado and New Mexico are in there keeping the balance, but it's not quite as progressive as the Ninth. And particularly on environmental law. And so a bunch of congressional Republicans, when Congress added parts of Yellowstone National Park that were in Idaho and Montana, you'll notice that most of the park is in Wyoming. Wyoming is in the 10th Circuit. But when they added portions of Montana and Idaho to Yellowstone National Park, Republicans didn't want, the hippy-dippy liberals on the Ninth Circuit being a bunch of tree-hugging environmentalists and applying regulations to the whole of Yellowstone National Park. So they passed a law that said that any cases that arose out of Yellowstone National Park would be adjudicated in the Federal District of Wyoming, and therefore in the 10th Appellate Circuit. But here's the thing. The United States Constitution requires that you be given a jury of your peers, and it defines jury of your peers as a jury of citizens from the state and judicial district from which the crime was committed. Now, nobody lives, there are no people that reside in the entirety of the Idaho section of Yellowstone National Park. It's mostly pristine, untouched backcountry wilderness. It takes, a couple days walk to get out there. But because it's a national park, state law doesn't apply. It's an exclusive federal jurisdiction. And you could not legally seat a federal jury that complies with the U.S. Constitution because nobody lives in the U.S. state of Idaho, but the U.S. federal district of Wyoming. See how that works? You're supposed to have a jury composed of people from the same state, same district, which mostly just means that if you're tried in Los Angeles, you can't have people from San Francisco on the jury. But nobody lives in Idaho and also the federal district of Wyoming. So, state law doesn't apply, and the feds can't seat a jury. So theoretically, you could do whatever you want in the Idaho section of Yellowstone National Park, and they wouldn't be able to try you for it. There would be no legal way to actually convict you for that crime. So, if you want to get rid of your annoying roommate, maybe invite them on a nice backcountry backpacking trip out into the wilds of Yellowstone National Park someday. Just saying. So the thing is, federal judiciary is actually a little more complicated than that simple diagram makes it out to be. Federal courts, or district courts, courts of appeals, Supreme Courts. Those are the big three. Those are the main ones. But, pretty sure I have in my art slides a view that's a little more complicated. This is really the organization of the U.S. federal courts. There's a number of specialized courts within the federal system. In reality, it's a lot more complicated than just District Court Appeals Supreme. Now you can see that they're in here. District courts are right here. Appellate courts are right here. Supreme Court, right? Oh, shoot. I forgot to talk about the extra 2 appellate circuits. So there are 13 courts of appeals. 11 of them are on this map. Right? They carry out, they serve those geographic districts like I described. There are 2 more, and they're both in Washington, D.C., but they're separate. So there is a federal judicial circuit for the District of Washington, which is its own appellate circuit. So if you go into federal court in Washington, D.C., it's the Federal District of D.C., and if you want to appeal that case, it goes to the special, Washington, D.C. District, or Washington, D.C. Circuit Court. But there's also an appellate court for the Federal Circuit, which specifically hears appeals about cases where the U.S. federal government is a party. So it doesn't cover a geographic area. It covers a subject area or a particular defendant, right? And so appeals courts, cases that go to the Court of Appeals for the Federal Circuit, those are typically cases that deal with civil rights, that deal with government, that deal with the interaction between citizens and those who govern them, right? Accordingly, appointments to the Court of Appeals for the Federal Circuit are kind of like the Supreme Court farm team, basically, right? So judges that get appointed to the Court of Appeals for the Federal Circuit, they often end up spending 10 years there and then ended up getting appointed to the U.S. Supreme Court when a spot opens. Though we all really hope that a spot doesn't open until a Democrat is president again. Please, Ruth Bader Ginsburg, don't die. Take my organs. So next point was that there are specialized courts outside of the Article 3 judicial system. So there are bankruptcy courts in every federal district. They decided that bankruptcy was too much of a caseload for the district courts to handle, so there's 94 U.S. bankruptcy courts that are specialized in each district that just handle bankruptcy cases. And if you lose in that court, you can appeal that to the district court, and then on and on and on and on and on. Right? There's also an enormous number of judicial and quasi-judicial organizations in the executive branch, outside of the official U.S. Official judicial branch. So For example, administrative agency offices and boards. If you have any sort of federal license, if you're like me and you hold two because you're a pilot and a radio geek, then you are subject to getting that license revoked or possibly administrative fines or things like that if you break the law, right? If you operate an aircraft without a license, most likely you're going to go in front of probably your local criminal court for breaking and entering and grand theft airplane, but you're probably also going to go to the FAA Administrative Board, and they're going to fine you. Actually, my usual example for this one is Harrison Ford, and actually he got himself in trouble again. So Harrison Ford recently landed at Hawthorne Airport in Los Angeles, and the controller told him to hold short of the runway, meaning, hey, I've got traffic going down this runway. You need to stop before the runway and stay off of it so that this airplane can either take off or land. I don't know which one it was. Well, apparently Mr. Ford did not hear that instruction and proceeded to go ahead and cross the runway. And we have regulations that are supposed to prevent that. You're supposed to read back all hold short and crossing instructions when they're given to you by ground controllers. But something broke down, and Harrison Ford put his airplane in front of another airplane that was using the runway. So he's going to have to go in front of the FAA Administrative Board, and they're going to decide whether he gets to be a pilot still. And given that this is just like a year and a couple years after he landed on a taxiway at Santa Ana Airport, which taxiways are not for landing, they're for taxiing, it would surprise me if he gets to keep his license with no limitations at this point. So those are administrative agency boards. As you can see, often you can appeal their decisions straight to the Circuit Court of Appeals. We also have an appeals office and a tax court built into the IRS. We also have an enormous number of courts in the Defense Department, and Defense Department and the VA. So we have the Board of Veterans Appeals and the U.S. Court of Appeals for Veterans Claims. So those are courts that deal with claims around veterans benefits. We also have the U.S. Courts of Military Review and the Court of Appeals for the Armed Forces. These are military courts. These are courts that are under control of the Defense Department. It should be noted that military courts are separate from the civilian courts for a reason. Military courts operate very, very differently. And one of the main differences being presumption of innocence. So in the civilian courts, you're famously innocent till you're proven guilty. It's the other way around in the military courts. You are guilty unless you prove your innocence. And so that is a major change from the civilian courts. They have a whole separate process. And somebody actually showed me the contract they had to sign to join the military, and it's like page after page after page of I waive my civil rights. And that's one of the civil rights you waive is the presumption of innocence. Fun stuff. So yeah, we have specialized courts to do military justice, tax disputes, terrorism, administrative stuff, bankruptcy, all outside of this simple tripartite organization. Oh, see, they had that slide for me over here. Okay, so diversity in the federal judiciary. Just below 1/3 of judges are women, compared to, again, a slight majority of the population. About 3/4 of them are white. We have a total of 1 Native American federal judge. Oh, and did I mention that Donald Trump is appointing hundreds of judges to the federal judiciary? How diverse do you think they are? You saw how diverse his cabinet was. How diverse do you think his judicial appointments are? He's appointed 2 white men to the Supreme Court. I mean, it's not getting better right now. The federal judiciary is not the most diverse place. In fact, it is often the place where diversity lags behind the longest. And that's for a couple of reasons. One is that there are so many obstacles in between between somebody and becoming a federal judge. How long has it been that women have been allowed to attend law school and go on to be clerks for circuit court judges and district court judges, go on to be to actually gain the experience necessary to gain the resume to be a high court judge? There's a lot of barriers in the way. There are obviously plenty of qualified women attorneys out there that would make great judges, but that has not always been the case. And compound that with the fact that the judiciary operates on lifelong appointments, you can see how it might take a while for diversity to kind of filter down to judgeships, especially when one of our political parties has a structural advantage to winning the presidency and also really doesn't think that people who aren't white and male are people. So that's the federal judiciary. Any questions so far? This is always kind of awkward because the video feed, and I can tell it lags by about 10 seconds. So I have to kind of just sit here and wait for 10 seconds while the, hey, do you guys have any questions? Question actually gets out to you. So if you have any questions, All right, moving on then. We'll talk about the court's role in our government and politics. Initially, this role was pretty minor. It was basically just kind of a super court of appeals. And it should be noted that, well, let's go back to the Constitution again. Here's our Constitution. I'm going to zoom it way on out. There we go. And remember, all of that is Congress, right? And then that little bitty piece is the president. Well, if that article defines a vague and imprecise office, Article 3 is truly impressive. Article 3 is very short and just doesn't have a whole lot of information in it. So the courts, much like the president, it says, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time establish. The judicial power shall extend to all cases arising under this Constitution, the laws of the United States, and treaties made or which shall be made under the authority, to cases affecting ambassadors, public ministers, blah, 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 blah. These are all the jurisdiction requirements we went over earlier. There's the jury requirement. And here is a bit about treason. And that's really it for the courts, right? There's not that much in our Constitution about the judicial system. It's not really all that clear how much power the courts should have. And so accordingly, the courts really didn't have all that much power for a really long time. The courts played a very minor role in the early years of the Republic, up until 1808 and the case of... no, that is what I wanted. Marbury versus Madison. So, this Marbury versus Madison was a case between, let's see, these fellows. President John Adams, who's the outgoing president, appointed Marbury just before his presidential term ended. They called them the midnight appointments. Right? So 1800 Thomas Jefferson, Aaron Burr, John Adams. Yeah, the guy who shot Alexander Hamilton ran for president. Jefferson and Burr split the votes of the Democratic-Republican Party. So Jefferson went on to very narrowly win the Electoral College. Federalists were not expecting that because they thought Jefferson and Burr would split the vote and they'd win a majority. Adams nominated 60 Federalists to, basically what were then district court, they were called Justices of the Peace, and circuit court positions 2 days before his term ended, because he wanted to make sure that, this crazy dude Jefferson's getting in office. I want to make sure that, good, solid judges are on offer. And so Jefferson supporters called these guys the last minute, the midnight judges, because the guy proposed these on the figurative midnight of his term. It wasn't actually at midnight, and the Senate approved the nominations, and those nominations went out. And then Jefferson got into office and was like, "Oh no." Jefferson got into office. His new Secretary of State, James Madison, was supposed to deliver basically the start paperwork to these judges. And he didn't actually manage, the old Secretary of State, John Marshall. That'll be important. The old Secretary of State ran around delivering the commissions, delivering the start paperwork, but he wasn't able to deliver them all before Jefferson's inauguration. And so Jefferson had like 5 or 6 of these judges start paperwork. Excuse me, there's somebody knocking at my door. Sorry, that was a mailman. Anyway, so James Madison was Secretary of State. Thomas Jefferson was president. Jefferson tells Madison, hey, those like 5 or 6 judges whose start paperwork you got on your desk still, do not deliver those. Those guys were Adams people, and we don't want them in the judiciary. So without their commissions, the appointees were unable to assume the offices, and William Marbury, this guy here, he was like, okay, so wait a second, no, I was just, no, we're not done. We're not done. I still see video. But William Marbury is like, hey, wait a second. You told me I had this job as a federal judge. Give me my paperwork. I was legally appointed as a judge. The president appointed me. The Senate confirmed me. Give me my paperwork. Let me start work. So this all goes to the Supreme Court because Marbury finally sues James Madison and is like, okay, you need to give me my paperwork, and I'm going to have the court compel you to do so. That put the newly appointed Chief Justice of the Supreme Court, John Marshall, who was Adams' Secretary of State, in a really awkward position, because observers at the time really thought that basically if the Supreme Court sided with Adams, Jefferson would just ignore them and just tear the papers up anyway. And so the Supreme Court would lose a lot of legitimacy. But if the Supreme Court sided for Jefferson, it would be a blow against the powers of the presidency. It would be saying that, if presidents do things at the end of their term, new presidents can just kind of overturn that if they want. So Justice Marshall threads this needle. And again, remember, he was involved in this whole thing. He was delivering the commissions of those judges, of those midnight judges. But Marshall tries to thread the needle of this whole thing. It says, okay, well, I'm not going to find that the commissions were valid or that they were invalid. What I'm going to find, he found some procedural reason that I don't fully remember, though I'm sure I could just flick over to the Wikipedia article and it would tell me. He found some procedural reason to overrule the Judiciary Act of 1801 that created the positions of Justice of the Peace, and so said that Marbury's job just didn't actually exist in the first place, that Adams had no job to offer. So he found a way to maintain the Supreme Court's power and maintain the power of the newly created presidency against the Congress, which was a big issue back then. And basically gave the court the power of judicial review, which is the idea that the Supreme Court can overrule acts of the other branches of government when they violate the Constitution. And so that is now a part of our system, right? The Supreme Court can overrule acts of Congress. That's not in the Constitution. The Supreme Court just decided that they could do that. You know, Justice Marshall just decided that, hey, you know what? I can overrule Congress and say that this act was not properly decided. Right? And so we now have the dichotomy of judicial activism versus judicial restraint. So some judges claim that, we should really respect the will of the people in our democracy, right? We should really respect that the people have elected certain people to rule them, and with certain policy platforms, we should only overrule those decisions as kind of a last resort, because the judges aren't elected in our federal system, and in the state they are, but in the federal system they're not. They're appointed, right? And so, how much democratic accountability do they really have? So some judges say, we should be very mindful of overruling acts of Congress. Others think that, the judiciary has an important role to play in that tripartite balance of our system of institutions, right? If we don't have an active Congress or an active Supreme Court looking over the shoulders of Congress and making sure that they're not violating people's rights, breaking the Constitution, well then the Constitution's going to get broken and people's rights are going to get violated, right? Oftentimes, judicial activism is levied as a complaint against progressive, judges kind of on the left and progressive policies. So, often pro-LGBT rulings were decried as judicial activism, or pro-Obamacare rulings were judicial activism. But it should be noted that pro-Obamacare rulings would actually be judicial restraint, right? That the elected government came up with Obamacare, and so judiciary overturning that would actually be active review of another branch of government, right? And so it should be noted that, Supreme Court doesn't do this whole nullifying acts of Congress very often. About really quick aside, you'll notice that these will say like Warren Court, Burger Court, Rehnquist Court, Roberts Court. We name Supreme Courts by the name of their Supreme Court, or the Chief Justice. So that was the Marshall Court that decided Marbury versus Madison, right? So the Warren Court and Chief Justice Earl Warren is kind of known as the kind of most progressive Chief Justice we've ever had, and so all of the really landmark civil rights cases and things like that came out of the Warren Court. Whereas Rehnquist and Roberts are both presiding over a much more conservative Supreme Court. So it should be noted that, under the hippy-dippy liberal Warren Court, 1.25 acts of Congress per year on average were nullified. Under the much more conservative Rehnquist Court, it was 2.16. So, it's not just people on the left that practice judicial activism. Oftentimes, conservatives can be plenty judicially activist in their own favor. So this slide is mostly about some distinctions on judicial processes. So we have a system in the United States called common law. A system of common law is a system where when judges decide a case, that decision stands not only for the case decided, but for all similarly situated cases. So, not just the case that's before us now, but any other case that comes up before us that's like this one in the future. So we have a concept of what is called precedent, where judicial decisions from the past are binding on judicial decisions in the future. That is why, for example, we are having this conversation about the court, why we have a section at the end of this slideshow called 19 Cases You Should Know, because those cases have an impact on our system of government, right? They change how the law is interpreted. And so for most of us, that's effectively the same as changing the law, right? So we have a system of precedent, and that is important to understand. Other countries practice what's called statutory law, or sometimes also called civil law, not to be confused with civil law versus criminal law. We'll get to that in a second. Those countries practice a system where, judges have to go back to the law books every time. Every case is reviewed anew. So cases at Supreme Courts in those countries are not nearly as consequential. So in the United States, we also have the distinction between civil and criminal law. Right? Civil law are cases that involve disputes between two parties. Most civil cases are filed by corporations, but if you were to file, say, an employment discrimination case, or a lot of family law is civil cases, right? So divorce is a civil case. You're not alleging your ex-spouse broke the law; you just don't want to be with them anymore. So divorce cases are often, like my divorce case was Nelson v. Nelson. Neither one of us is a Nelson anymore. So criminal law are cases in which someone is charged with breaking the law, right? So where somebody did something that carries actual criminal penalties, something that's illegal, right? In civil law, we talk about cases in terms of plaintiff and defendant. There's a party who brings the action and the party who upon who the action is brought. So, if you had an employment discrimination case, if I brought an employment discrimination case against, say, my former employer, CCSD, which I'm very strongly thinking about, I would be the plaintiff in that lawsuit. They would be the defendant, right? So it'd be, Martin v. CCSD. In cases of criminal law, as we're going to see, we've talked about cases where this is the case. Cases of criminal law, the plaintiff in criminal law is actually the people of whatever jurisdiction the law is broken. The courts see that crime is an offense against society. So it is basically, criminal law, you are basically being sued by society at large, with the local district attorney being the avatar of society, as it were. So, criminal law cases are often like, so-and-so's name v. or, when I got a traffic ticket because somebody else totaled my car, and I'm so pissed about this. I am so pissed. I got an $800 traffic ticket because somebody was coming up Rainbow, and I turned, but Rainbow was stopped up with traffic, and I turned across Rainbow at Del Rey there. And all three cars are stopped here. Somebody decided to come up that the breakdown lane there on the right and slams into my car. Cop gets me for failure to yield. Failure to yield to a car that wasn't even supposed to be there in the first place. But, I have an attorney friend who's like, just don't even bother fighting it, you won't win. So, pled it down to half the fine and no points on my license, which I guess is great. But, point is, that case was named, Clark County versus Nelson at the time, right? That case is Clark County, the people of Clark County, versus me, the person who has wronged the people of Clark County by, failing to yield to an oncoming car, which was in the breakdown lane, so it should have been a right turn only. So anyway, so if it should be noted that sometimes plaintiff and defendant will switch places on appeal. So the case of Miranda versus Arizona. That started as Arizona versus Miranda, right? It was the state of Arizona prosecuting Ernesto Miranda for kidnapping and whatever. I can't remember his exact charges. But when he appealed that decision, he became the plaintiff because he was the one filing the appeal. So it became Miranda against the state of Arizona, Miranda v. Arizona. Happened to you too? That's so terrible. I'm just like, we spent like 2 hours waiting for that cop to come out just for him to cite both of us when this dude was like obviously in the wrong. Yeah, I crashed right into that, that mattress store right over there on Delray and Rainbow? Crashed right into that sign. Destroyed. I had this beautiful cherry red Veloster, and I love that car, and I hate cars. I love that car, and I am pissed about that. And for the cop to come and cite me for failure to yield, I was furious. But anyway, I'm going to stop ranting because this has nothing to do with the judicial process. Y'all should get this clear, though. Common law system has precedent, right? Civil law is lawsuits. Criminal law is when you break the law. Plaintiff is the person who sues. Defendant is the person being sued, right? Probably know this from watching too much Judge Judy when you were sick as a kid at home. I guess kids don't actually do that anymore. I'm so jealous of the younger generation, because when I was a kid and you were stuck sick at home, you had daytime television to watch, and it was Price is Right and Judge Judy all damn day, or like Maury Povich. And now it's like all these kids got their Netflix, and you can just sit at home and binge watch whatever it is that you want. And I am like, y'all, you don't understand the struggle of having to sit through 15 hours of well, not 15 hours, but like 4 or 5 hours of Price is Right and Judge Judy. You don't understand the struggle. I'm going way off topic today. I am off on tangents. So, court's role. We have at the top of our judicial system 9 unelected judges appointed for life, pretty much impossible to remove, that have the final say on what exactly it is the U.S. Constitution and the laws of this country say. Is that too much power? A lot of people would say yes. A lot of people, especially looking at Kavanaugh and Gorsuch, would especially say yes. Courts have an enormous amount of power to shape American policy, and the Supreme Court is often where final decisions are made about our politics. And increasingly it's become obvious that the Supreme Court, like every other branch of our government, is a partisan political institution, and it is one that is very firmly in the hands of the conservative side of our politics right now. And so, for a lot of people, that's very scary, right? I mean, it scares me. There are Supreme Court cases in front of the court right now this year that we're looking on a decision probably next month or so, next month after, that may overturn every single state law currently protecting LGBT rights. All of them. Because it's somebody's religious freedom to fire me for being gay. So, I mean, that scares the hell out of me, that these unelected politicians could basically ruin my life. Make it legal to kick me out of my apartment or fire me because of who I am. And there's very little I can do about that. Besides, vote for, Joe Biden. Because at least he'll replace Ruth Bader Ginsburg when he dies with a liberal. When she dies, I'm sorry, Ruth Bader Ginsburg, and I'm sorry for being morbid. But that's scary, right? That's a lot of power. On the other hand, Alexander Hamilton said that our courts are the least dangerous branch of our government. for a couple of reasons. One is that they have really no electoral base, right? There is a certain level of illegitimacy that goes along with Supreme Court decisions. And it's probably a lot more likely that somebody from the general public would ignore a Supreme Court decision more than they would ignore the decision of the president or an act of Congress, right? The courts also have limited resources. Congress has tens of thousands of staffers that work for it every single day. The president has tens of thousands of staffers that work for him, and then the whole executive branch. The president is commander-in-chief of the army. But the Supreme Court, couple dozen law clerks, right? So there's 9 Supreme Court justices. They each get like 3 clerks, so there's like 27 law clerks, and that's about it. So there's very limited resources on the part of the Supreme Court to enforce their own decisions. So this court really does rely on other branches for enforcement. And we've seen cases in the past where our other branches of government have absolutely ignored the Supreme Court. I mentioned the case of U.S. v. Cherokee Indians, right? U.S. v. Cherokee Indians, where the Cherokee said they had tribal rights to their ancestral lands in northern Georgia according to a treaty that they signed with the U.S. government, which, remember, lands them in federal court. Federal courts cover treaties. And the U.S. Supreme Court said, yes, the Cherokee have a treaty. They have a right to stay where they are. This is their land. And the President of the United States, Andrew Jackson, turned and said, to the Supreme Court, let them send their army. Right? Basically, I've got the army and you don't, so we're doing this. And so the Trail of Tears, again, one of the worst atrocities in American history, a forced march through the winter where a third of the Cherokee died in driving them to Oklahoma and clearing them off their ancestral homelands. That was done against the order of the Supreme Court. So the Supreme Court relies on its legitimacy, relies on other branches to actually pay attention to what it says. Otherwise, it really doesn't have all that much power at all. Furthermore, the Supreme Court is also not allowed to be an activist institution. The courts have to hear a case first before the Supreme Court can take it up. And there has to be an actual case for it to be heard in the courts, as we'll see here in a moment. Actually, you know what? I think I'm going to save the operation of the Supreme Court for our conversation on Monday. Just because if I start on it now, I'm going to want to get through all of it, and that's going to bring us, well further into the 10 o'clock hour than I really want to be. So, let's call it here. I will see all of you next Monday. Next Monday at the regular 10 a.m. time. I will make sure that I am awake. I will figure out why it is that my cell phone didn't go off, and had a very stern talk with my cat. He really needs to take his responsibility of waking me up more seriously. And until then, I hope you all have a great weekend in this era where time is meaningless and weekends do not matter. I hope that all of y'all's essays are coming along great, because they are due next week. Next Friday, the essays are due. You do need to turn them in through Canvas by midnight on Friday. I'm just going to extend the deadline to midnight on Friday, because why not? Time has no meaning. And until then, stay in place, keep your space, cover your face, stay safe out there, and I will see you Monday morning.